So a very warm and fussy welcome you all to this winter evening and to our last London Shipping Law Centre YMP event. This is actually our final event, as I said, before the Christmas break. And we really hope to inject some Christmas cheer to your evening with this very popular topic on expert evidence in maritime dispute. This event has been tremendously popular with more than 300 people signing up. And so thank you to all the participants for joining us. In case any of you don't know me, please let me introduce myself. I'm Francesca Cappa. I'm chairing the Young Maritime Professional Association, and I am a shipping lawyer at MFB. Many of you would be familiar with the London Shipping Law Centre and the YMP, but for those who aren't, the YMP is a London-based social networking educational association founded in 2011 by Dr. Aleka Shepard to support young professionals across the maritime industry. I would like to take this opportunity to thank Dr. Aleka Shepard for her unwavering support to myself and to the YMP. The YMP is part of the London Shipping Law Centre, and our aim is to promote cross-sector networking, education, exchange of ideas, and of course, further professional developments. We run events from webinars, like the one we're having tonight, discussions, short talks on site, and purely sometimes social events. And of course, the pandemic has been very, very challenging for us, but for all the challenges that the pandemic has presented, and as much as we all miss in-presence events, one of the blessings of going virtual is that we've been able to broaden our horizons and reach a wider and more international audience. Despite the different time zone, we have tonight delegates joining from as far as 32 countries. So once again, a very, very thank you from my side, from myself and from the YMP for joining us tonight. Before we get started, I would like to thank MFB for their support to this event, and of course, Ed Gray, and all the speakers for their time and incredible efforts. I know how much time and effort goes into preparing for an event like this, so thank you all once again. I shall now hand over to Andrew Stevens, who is moderating this evening. He's a barrister for PAM Court, specializing in international commercial dispute resolution, and of course, a member of the YMP committee.
Thank you, Francesca. I hope I'm not on mute and that people can hear me. If you can stick up a thumb.
Yes, we can.
Okay, great, thanks. Welcome, everybody. I second Francesca's very warm welcome. The format of this webinar is that we're going to have 3 speakers on London maritime arbitration and litigation and the approach to expert evidence from a London-centric point of view. Then we're going to hear from a civil law point of view, how to deal with expert evidence, how to get the best out of expert evidence, how it works in a more civil law setting. And finally, we're going to hear from a New York perspective, where many of you may be aware that preparation of witnesses is allowed, whereas it's not in somewhere like London. So we're going to start off, as I said, with the English section. We're very lucky to have been joined on this webinar by 2 experienced expert witnesses. We're going to start off with Robert Aberdour, who is a shipbroker and expert witness at a company called Shipping Expert Witness. And without any further ado, I shall hand over straight to Robert.
Today, I'll be talking about the best practices for expert witnesses in English arbitration and how lawyers and expert witnesses can best work together. Next slide, please. In England, the expert is party appointed. However, the party's overriding duty is to the tribunal. The expert's duty is to provide the tribunal with their honest, balanced, and independent opinion. To facilitate this, the expert must be provided and should consider all the relevant available evidence, even if the evidence is not in the instructing party's best interests. On occasion, I've been asked not to include certain key evidence within my report. some instructing lawyers have been known to comment that you're not writing the other party's defense. However, an expert that does not give their balanced, even-handed opinion will not only breach their duties to the tribunal, but will also undermine their own credibility, thereby diminishing any genuine points of merit that the expert has highlighted. It should be remembered, dismissing the evidence is the job of the tribunal, not the expert. Next slide, please. Acting as an expert witness, I've had a range of partisan requests, from a suggestion that instructions will be forthcoming if my opinion agrees with the client's views, to being asked to sign a report that the instructing party's lawyer has already pre-prepared for me. It is ill-advised for an expert to stray into any form of partisanship. The whole of the expert witness process in England is based on independence, from the expert's report to the joint expert meeting to any cross-examination. The diluting of an expert's opinion during any part of this process is comparable to cracks appearing midway through the construction of a house. The cracks will be plain and obvious to see and will highlight that something is not solid and stable. These metaphoric cracks might manifest themselves when an expert sticks rigidly to certain points, uses emotive language, or when an expert displays a palpable lack of confidence in what they're saying. This could lead to lingering doubts about the expert's independence and credibility, and potentially result in poor performance by the expert when cross-examined. No self-respecting expert will ever entertain requests for partisanship, as it's a zero-sum game, which could potentially waste the instructing party's time and money. The expert's honest opinion from the outset will not only comply with the expert's duty to the tribunal, but will also assist the instructing party's legal team understand their actual position and how best to deal with the dispute. Next slide, please. Instructions to an expert are a vital stage in the expert witness process, but in some situations, the instructions are either not clear, not complete, or are partisan in themselves. In these circumstances, an expert should be able to query or clarify their instructions so the expert can answer accurately, honestly, and independently. Dialogue between the expert and the instructing lawyer is beneficial and should be encouraged. When responding to the opposing expert, it should be remembered that disputes are often nuanced with a possible range of opinions. Considering and addressing alternative opinions from the opposing expert should be encouraged. It's not a sign of weakness to concede a point or give credit to the opposing expert if and when appropriate. Next slide, please. Being party appointed, there will always be a desire to keep the expert witness fees to a minimum. However, cutting corners should be avoided. An expert should be given a realistic time frame to properly review all the documentation. If there's too much pressure to keep costs down, mistakes and errors can follow. Errors in calculation and failure to read documents thoroughly due to unrealistic time restraints may be useful ammunition and low-hanging fruit to any barrister in cross-examination. Next slide, please. The common law system offers parties flexibility when choosing their expert witness. Getting the right expert is an important decision in any dispute, and ensuring the expert has the right experience and the right qualifications is essential. Experts should never stray outside their field of expertise. One possible source of experts for shipping disputes is the Baltic Exchange Expert Witness Association. This association has a list of over 70 experts, each with their own specific field of expertise. As such, it may be a useful reference point. I would also recommend that an expert is brought in at an early stage of the dispute process. In initial exchanges between the parties, I have on occasion seen inaccurate statements being made in matters related to quantum. Perhaps the most common of these is the comparison between different vessels in the determination of losses. Quantifying losses by comparing different vessels is not as straightforward as it would seem. Apart from the obvious size differential between the vessels, there's a number of other significant variations. Slight variations can have a disproportionately large effect on the vessel's likely net earnings. For example, if you compare two identically sized sister vessels, but one vessel is fitted with a scrubber that allows it to burn the far cheaper high sulfur fuel oil, that one small variation will save several $1,000s per day whilst at sea. As such, calculating the earnings of one vessel against the other by simply comparing relative deadweights, the relative size of the vessel, can be extremely inaccurate and is often better calculated by the expert. Next slide, please. To summarize, in England, it should always be remembered that the primary duty of the expert witness is to assist the tribunal by providing an opinion that is impartial, objective, and independent. In the forefront of any expert's mind should be, what would a reasonable, well-informed person conclude in the given situation after careful consideration of all the evidence? If the expert achieves this, the instructing party will not only get an honest, reliable opinion, but it is far more likely that the tribunal will consider the expert's evidence favourably. Next slide, please. Thank you for listening. And back to Andrew.
Thanks, Robert, for that really interesting presentation. Before we move on to our next speaker, to segue into it, when it comes to tribunals reading into expert issues and expert evidence in a case, I think it's a good bet that the experts will start by reading, the arbitrators will start by reading the joint statement of the experts. So I think it's quite important that the joint statement should do as good a job as possible of identifying the actual issues in dispute and why it is that the two experts differ on the remaining issues in dispute. But sometimes I've seen in cases a number of instances of the more experienced expert, or perhaps more streetwise expert, taking control of the joint statement process, the drafting process, in a way that can put one side's case slightly better than the other. So we're very lucky to hear next from Jean Richards, who is an expert at Quantum Shipping Services.
Good evening, ladies and gentlemen. It's a great pleasure to be with you this evening. And as Andrew said, I have probably quite a lot of experience in giving expert, but it also goes with a fairly long career in shipping, because I started in shipping in 1973. And I have worked for various number of owners. I'm a fellow of the Institute of Chartered Shipbrokers. And it's only in more recent years have I been giving evidence most of the time. I was repossessing ships for banks. We took over the Adriatic tanker fleet. So I'm an owner and a shipbroker and an experienced analyst. Next slide, please. Next slide.
Here with me, Jean. Yeah.
Now, the mention came from taking control of the joint memorandum exercise, and somebody experienced like me does absolutely take control of the joint memorandum role. And the reason being is that the goalposts were moved about 10, 15 years ago. Historically, the timetable was that you exchanged experts' report, then you wrote a second report dealing with what you thought about what the other expert was saying. Then you had an expert meeting, then you did your joint memorandum. Next slide, please. What has happened now is it changed, and you exchange experts' report, then you have a meeting, then you do your joint memorandum, and then you have a supplementary report if it's necessary in order to deal with the differences. Next slide, please. Mm-hmm. Now, the biggest problem of this is the old method. When you saw and read your other experts' report, you could know exactly what the numbers was. And quantum and the calculations are sometimes very complex. And as a fact, you then get to a meeting, you don't know which assumptions the other expert is going to be critical of. You haven't got the chance or the opportunity to recalculate the numbers at the joint meeting. And therefore, you are in a position where you facing each other, not actually really knowing where the other expert is disagreeing either with your sums or with your calculation. Next slide, please. And so the only solution to get around this new timetabling I found was that in order that the other expert understands exactly why you have taken a different approach to his approach, why you're actually together not going to agree, is to have a draft memorandum prepared well in advance of the meeting. So the draft acts as an agenda. It sets out, from understanding and reading both reports, it sets out the areas of agreement, the areas of disagreement, and it starts as the draft document where you can then go to a meeting. You have the opportunity possibly of doing new calculations. You can see where you're trying to get to with the joint memorandum because it's actually then been set out. Now, somebody needed is quite often me. Somebody does need to take control of the situation because of the change in the timetabling, which left you with a great vacuum because you weren't sure what the other expert was going to criticize in your report. And I've seen two expert reports quite often being totally different because the instructions weren't even the same. So it does try to address that. And then what happens in a good day with a good other expert, you will sit at the meeting and we be able to actually finalize by doing the amendments then and there and sign it before you actually leave the room. And that is a very good process. If you can't agree with everything, you can agree what you don't agree, and that's when you do your supplementary reports. Next slide, please. The biggest problem that then you face is, in fact, that the lawyers try to interfere with this process. So I have faced some lawyers who insist on writing an agenda for the experts meeting, which is very biased for their own side. I've found them wanting to insist with their experts that they see the joint memorandum before the experts sign it. And I've even seen them actually changing the English and trying to have editorial rights over it. And the telltale signs for me are twofold. One is the other expert, we agree the draft, we agree what we've agreed at the meeting, I send a markup, and the other expert takes a fortnight to get back to me. Clearly, he's discussing it with his lawyers. Or he comes back to me and a whole wodge of the stuff that we'd agreed gets redacted. And he says, oh no, I'm not instructed to talk about this, which is not helpful either for the tribunal or for the process to actually have that sort of interference between experts. Next slide, please. And one of the other things not covered by Robert, which I'd like to add in, not to do with the joint memo, but a separate issue, is I have found over time that I am faced quite often with experts who are not truly independent. They actually regularly do business, are the shipbrokers for, and they actually can't be impartial because their whole livelihood is dependent on the party whose experts they are. And so I think you can know somebody and be impartial, but it's far more difficult. The other thing I do find, I've worked with the same lawyers on many different cases, but I've worked with a lot of lawyers, and there are some lawyers and barristers I like to work with. There are others that I find quite difficult, and I'm sure they find me very difficult. But the main thing is that I tend to take an appointment on the first come, first served basis. So if I get a phone call from a lawyer I don't know and I accept the appointment, and a couple of days later I get for the same case, a phone call from a lawyer I do know, I don't change my mind and go with the lawyer I know. I go with the lawyer I don't know because they asked me first. And the last one, because luckily I'm not a day-to-day broker, I am not that close and my income does not depend on business I can do with a particular owner or a particular client. And therefore I can avoid as much as possible knowing the parties or in any specific case. And I do try to avoid having lengthy meetings with the parties in question. Sometimes you can't avoid it, but it helps you to be impartial if you don't know them. Next slide, please. The last thing I was asked to say a little bit about was the difference between arbitration and litigation. I don't think there's very much difference between the judge and the tribunal. And I know that we now later on got witnesses. You're going to have a panel talking about civil law. You're going to have a panel talking about the states. I've given evidence in the states. I've been deposed. I've given evidence now in 13 jurisdictions. And the High Court, Appeal Courts, they are different, but the difference isn't between litigation and tribunal. The difference is between jurisdictions. And I gave evidence in Oslo on one occasion where instead of passing a post-it to the barrister cross-examining the other expert, I was allowed to put my hand up and actually cross-examine the other expert myself. So that was one good thing. The other, could you go back, because that jumped?
Sure.
So that was one case. Recently in America, which puzzled me immensely, I was asked to give a 30-minute PowerPoint presentation summarizing my evidence. So that was very much different from the deposition and the prepping that I was expecting. And the last one was an appeal court in Oslo, who I got to the appeal. I expected the barrister to take me through a few questions in chief. And all he said to me was, "Mrs. Richards, what would you like to say?" And at that point, I wanted to say goodbye. And I will leave my presentation there and say goodbye. Thank you for your time.
Thank you so much, Jean, for that excellent presentation. Before handing over to Francesca for the civil law segment of the event, I've been asked to say just a little something about cross-examination from the point of view of English counsel. In a nutshell, cross-examination of experts is basically putting questions to the other side's expert to try to expose reasons why that evidence should not be preferred or accepted by the tribunal. Now, most of you know that. That's teaching granny to suck eggs, but it's worth stating. When preparing cross-examination, generally, I find that I not always, but most of the time, need assistance and quite a bit of input from the expert appointed by my client to really get into the issues that, or the questions that need to be put to the other side's witness. So it helps if your witness has got experience of being cross-examined and knowing what to look out for, because they will be able to help you to prepare your cross-examination. Generally, the major things that we usually look out for to form the basis of our cross-examination, there might be 4 or 5. Number one, assumptions. You work out the chain of logic in the analysis by the other side's expert, and you look at where they've made assumptions that might be right or wrong, and that's can be a fruitful ground for cross-examination. Secondly, evidence that's been overlooked. Why have they overlooked it? Is it because it doesn't help establish their point of view? Thirdly, bodies of contrary opinion. Why have they not taken that into account if they haven't? Fourthly, the data. Often preparing cross-examination can involve a lot of Excel spreadsheets and crunching through numbers and trying to make graphs yourself to replicate the graphs that the other side's expert has produced, to see if you change the parameters, it looks very different, because that can be quite a good question to put. And fifthly, there are always specific points relevant to each particular case that you might want to raise in cross-examination as to why the other side's expert is wrong. But having flagged those up, when the experts are working on their reports and writing their reports, if they know about those kind of questions and the things that counsel looks for on the other side, it will make them write a better report, and probably a more accurate report, frankly, if they take all the evidence into account and they deal with contrary opinion and they avoid wrong or sloppy assumptions. And the final point from me on this is the style of cross-examination, each to their own. But sometimes clients can want fireworks or aggressive questioning in cross-examination, or sometimes they want you to take points that are just not relevant to the issue that the tribunal's got to decide. My point of view is that tribunals usually start from a position of wanting to accept the evidence and to accept the expert as trustworthy. And it's quite hard to undermine that initial will to trust merely by accusing somebody of bias. It's very rare that there's a smoking gun that really shows that this person is deeply biased and can't be listened to just because they're biased. My view is play the ball, not the player. And I think the best cross-examination demolishes the logic of the expert brick by brick. It doesn't do it in a dramatic detonation or in an ad hominem attack. So on that, I shall hand over to Francesca for the civil law segment.
Thank you very much, Andrew. And actually, I shall now introduce the next speaker, who is Professor Luca Guerrini. He practiced law as an Italian lawyer, but is also Professor of Private Law at the University of Genoa.
Good evening, everybody. And thank you very much, Francesca, and all the organizers for this event. I just ask you, yes, if you can share my slide, please. Thank you very much. So once again, let me express my thanks to Francesca Kappa and to the organizer of this event. That said, next slides, please. It is impossible to describe what expert evidence is under the Italian legal system without shortly explaining the framework of the main principle and rules of our civil and procedural codes. According to the principle of party disposition, the parties have the right and the duty to frame the fact pleading and to provide the related proof. Therefore, the court cannot look for new facts or new evidence of its own motion, we say ex officio, and must base its judgment on limits and proof submitted by the parties. Next slide, please. According to the principle of onus probandi, providing proof of the facts is a burden of the parties who are not required in our system to disclose the existence of documents that affect the case. And under this principle, claimant has to prove facts on which his claim is based, and respondent must provide evidence of facts that exclude the liability or show that the right has been exhausted or changed in such a way that the claimant's claim should be dismissed. Next, please. From 2009, court consider facts to have been proven regardless of the evidence submitted by the party making the claim, if they have not been specifically disputed by the opposing party. We call it no challenge principle and is provided by our new Article 115 of the Procedural Code. Next slide, please. I also have to mention that our procedural code set strict timeframes. We call them termini perentori, so deadlines, for filing documentary evidence, for example, public and private documents, accounting records, email, and so on, and for requesting admission of non-documentary evidence. I refer to witness evidence and confession or formal questioning. In Italy, the witness is orally questioned by the court, and the party can neither examine nor cross-examine a witness. And I think it's interesting for you to know that under our code of conduct, counsel have limitation on speaking with witness even out of the court. Lastly, I underline that statements made by a party that are favorable to such party do not count as evidence. On the contrary, a confession statement, adverse to the party that has made it in court during formal questioning, will count as evidence against such party. Next slide, please. With that in mind, we can now better focus on what expert evidence is. In Italy, the activity of an expert is called technical advice. We say consulenza tecnica. This name brings into relief the role of consultants as auxiliaries and the level of technical expertise that is their distinguishing characteristic. Technical advice is not an instrument of proof in our system, but a method for checking evidence submitted by the parties. And please consider that courts can order technical advice of their own motion, but parties cannot agree to exclude it. Next, please. Case law highlights two different functions of technical advice. Sometimes the technical advice is necessary for evaluating facts already proven by the party. In this case, we speak about deductive advice. But in other situations, technical advice is necessary for ascertaining the fact presented by a party to substantiate the claim when the court considers that the relevant findings require technical knowledge that the party does not have. And in this situation, the parties still have the burden to provide evidence, and the task of the expert is to confirm the facts alleged by the parties. To better understand this second function of the technical advice, we call it in this situation perceptive advice. Please consider that under the Italian system, there is no burden of submitting to the court technical or scientific knowledge, even if it is necessary for the judgment. Next, please. Let's see now how it works, selection and appointment of the expert. Experts should normally be selected from amongst a list divided by category held at each court. So we have list in Genoa, in Milano, and before each court of Italy. The list is kept by a committee chaired by the president of the court and is subject to revision each 4 years. The court appoints a single expert, expresses the questions, and gives a time limit for submitting a report, normally 90 days. Parties may nominate their own expert, but please consider that the opinion of the party's expert is considered only as an assertion of the party, so it is not a proof. The expert then takes an oath to faithfully fulfill the task received in order to make the truth known to the judge. In arbitration, of course, there is no obligation to select consultant from appropriate list. Appointment is a matter for parties and discretion of arbitrator. Next, please. Something now about the activity. How the expert goes about the task assigned is up to him or her. The parties have a right to participate in the expert examination and assessment, make their observation, and propose different conclusions through their own technical consultant. The expert can be authorized to ask for explanation from the parties and to make inquiries. And the report is in writing and divided in several parts. So we have heading, preamble, scope, development of investigation, verification of facts, technical evaluation, conclusion. And please consider that the opinion in Italy includes legal question related to the technical issue, just for example, causation and damages. Expert may be requested by the court to supply oral clarification at the hearing. And I have to add that the parties can propose to address questions to the expert, but only the judge is formally entitled to ask for explanation. Next, please. Last point. Please, the next one. Thank you, Manchester. Last point concerns the binding effects. Although expert reports bring in technical expertise that the court does not have, they are non-binding opinion. In Italy, the court has full discretion in appreciating the expert arguments and conclusion. We use the Latin expression that the judge is peritus peritorium, that means expert of the experts. The court so can follow and agree with evaluation and conclusion reached by expert, but is not bound by the opinion expressed and may ignore it in the event it is not convinced by the logical reasoning followed and or technical criteria adopted. In both cases, the court must explain why the final conclusion of the expert are acceptable or non-acceptable. Next, please. Should the court decide to follow the opinion of the expert, it will quote the most significant parts of the technical opinion without being obliged to confute the critical observation of the parties' experts. I can say that the court followed the expert in more than 19% of the cases. On the contrary, the court will have to illustrate the reason that induced it not to follow the opinion of the expert. Where in doubt, the court may at any time appoint another expert and order a new technical advice. In summary, in Italy, we have no battle of experts appointed by the party, but one court-appointed expert that works for the judge. Next, please, where I briefly conclude. I would like just to highlight a few points. First one, the appointment of the expert is one of the rare examples of inquisitorial power exerted by the judge in the Italian civil proceeding, as it does not depend on the party's intent or application. Second, the expert is not indicated by the parties, but appointed by the court. The question, even if proposed by the parties, are decided by the court, and only the judge examines the expert without cross-examination. The idea is that in this way, the expert is independent, impartial, neutral, and exclusive, looking for the truth. Next, please. The expert opinion is, however, not proper means of evidence in our system, but rather a means to evaluate and interpret the evidence that has already been taken into the proceeding. In fact, expert has no exploration duties that could lead them to exceed the limit of the principle of party disposition and border of proof. And only in cases of particular technical difficulty, case law widens the expert role from mere deduction, I mean evaluation of documentary facts already acquired during the proceeding, to active investigation, I mean identification of the fact that it was not possible to prove with the ordinary means of evidence. The last thing is just to thank you very much.
Andrew, we shall hand back to you.
Thanks. So I think that concludes the civil law section. And now an attorney who needs very little introduction for many of you, I'm sure, who would have heard Alan speaking before at LSLC events, is Alan van Praag, a senior attorney at Chalos & Co. in New York. Alan is now going to tell us the New York perspective on expert evidence. Over to you, Alan.
Okay, thank you for that introduction, Andrew. The subject of expert testimony in New York is a very large subject. I have attempted to synthesize the subject and to highlight expert testimony in two forums, the arbitration forum and in court. In the arbitration forum, if you have a dispute where you require an expert, there are specific experts that you know from your experience, and I've been practicing a long time, who handle particular claims. speed claims, redelivery claims. For example, what you would do is you would meet with the expert and go over the issues that are in dispute and ask the expert for a report, of course, in the anticipation of appearing before the arbitration panel. The expert will, of course, ask us for additional information if necessary, and may even go to a scene of a casualty if that's necessary to prepare his report. Once the expert's report is in draft form, we meet with the expert and go over the report and ask the expert if we can tweak certain sections or we can get some clarification on sections that we want to make clear before the panel. Then, before the arbitration, we exchange expert reports at a date set forth by the arbitrators. And at the arbitration, before the arbitration hearing, we meet with the expert. And as you said before, we prepare the expert for his testimony before the arbitrators. We go over his direct examination and we prepare him for cross-examination. And we also ask for his assistance with regard to the cross-examination of the opposing counsel's expert witness, similar to what you do, Andrew. Then we have the expert testifying. And in my experience, arbitrators, though you have the right to challenge the expert opinion and seek to have it excluded on the grounds that the expert, upon your voir dire, is not qualified to testify on that subject or on that issue, or that the issue is not germane to the dispute, or on other grounds you seek to exclude testimony from the expert. In my experience also, the arbitrators will take expert testimony for whatever it's worth. They're going to rely upon fact witnesses, exhibits, the expert testimony, and probably most important of all, their commercial experience in rendering an award. However, the situation is far more complicated when you're dealing with a court situation. Now, if you have a clause calling for US jurisdiction, or you want to bring a case into the United States, I would recommend that you go to the United States District Court, Federal Court in New York. I say that because the Federal Court in New York has a great deal of maritime cases, and the educational load in educating a judge as far as education, as far as maritime terminology is concerned, and as far as technical issues is concerned, is much less. I would totally avoid any jury trials on a maritime claim, because it is very hard to educate a jury on maritime terminology and technical issues. So you're going to use an expert witness. The first thing you have to do is to file a Federal Rule Civil Procedure, Rule 26A2, disclosure of expert testimony, which includes a written expert report signed by the expert, a complete statement of all opinions the witness will express, the facts and data considered by the witness informing of his opinion, the qualifications of the witness, other cases within the previous 4 years where the witness has served as a testifying expert, and a statement of compensation. Now, I have used this document many times for cross-examination purposes of an expert, but it includes some items of gold for cross-examination purposes. So once you have a date set by the judge for the exchange of expert reports, but you assume the other side is going to have an expert, you will also have a date set for the judge, by the judge, for taking the oral testimony or deposition of the expert. I usually always take the oral deposition of the expert because I want to cross-examine him and perhaps get his views on the record, and I can use his oral testimony for cross-examination should he testify live at trial to try and find prior inconsistent statements for cross-examination purposes. Maritime claims are only heard before a judge. You have a bench trial before the court. So the court is the ultimate trier of facts. So you go and take the deposition of the expert. It is interesting that I utilize almost all of the facets of cross-examination that Andrew recited, but I must admit being a New York lawyer, I am a bit more aggressive than the English are, I think. So in any event, we take the deposition of the expert witness, and after the expert witness's deposition, which could take a few days, depending upon the length of the deposition and the number of issues involved, you can make what is known motions in limine before the judge. These motions in limine would be to exclude the testimony of the expert entirely, based upon your voir dire that the witness is not even qualified to testify on the subjects in dispute. You can exclude certain aspects of his testimony on other grounds, and you continue on. The next thing is the trial. What is the role of the judge when you have a bench trial? The role of the judge in the United States is to act as a gatekeeper with regard to the admission of evidence, and in a bench trial as the determining party for the credibility of the witness. Now, in determining the admissibility of expert evidence, the courts are guided by the United States Supreme Court case, Daubert. In Daubert, the court went certain standards, and there were 3 words that I want everybody to remember anything. That is relevant, reliable, methodology. Those are 3 standards upon which Daubert is founded. Indeed, the Daubert standards were codified into Rule 702 of the Federal Rules of Evidence, where a witness who is qualified as an expert by knowledge, skill, experience, training, or organization may testify in the form of an opinion or otherwise if the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. The testimony is based on sufficient facts or data. The testimony is the product of reliable principles and methods, and the expert has reliably applied the principles and methods of the facts of the case. Now, these Daubert factors are merely illustrative. They're not exhaustive. The final factors of Daubert, which sound more like a testing for a vaccine, are that they are acceptable by the scientific community, that they have been tested in accordance with the scientific community, and there is peer review. In sum, an expert opinion is reliable if it is based on proper methods and procedures rather than subject belief or unsupported speculation. The test for reliability is not the correctness of the expert's conclusions, but the sound of his methodology. Again, methodology, reliability, relevancy. The court must ensure that the proffered expert testimony is relevant. As articulated in Rule 702, expert testimony is relevant if it assists the trier of fact in understanding evidence or in determining a fact in issue. Thus, the party proffering such evidence must demonstrate a valid scientific connection or fit between the evidence and an issue in the case. That's it. Thank you very much for your attention. I look forward to answering any questions you may have.
Thank you very much, Alan. Thank you very much, Alan. Can you all see me?
Yes, I can.
Great. Thank you for this. And finally, let me introduce our final speaker, who doesn't need an introduction really, and many of you will know Ed Gray. Ed is a very experienced litigator and arbitration practitioner with over 40 years experience. He's a partner at my firm, MFB, and Ed is going to end the session before answering any questions. So if you do have any questions, please write them in the Q&A. I can see we have some already. And then Andrew will put them at the end. And now I shall hand over to Ed.
Thank you, Francesca. I think I did need introduction since I've crept in under the name Paul Whiting. He's our IT person, and so he set me up. Apologies for that. I think we're running a bit short of time, so I'll just launch straight in, if that's okay. I'm interested in the differing approaches of common law and civil law systems, the one which favours party-appointed experts and cross-examination, and the other which leans more towards court or tribunal-appointed experts. But tonight really is much more about the practical side of things. If anybody is interested in a discussion of the benefits and the downsides of the two approaches, then there is a short memo on the LCIA website which discusses the pros and cons. I might just say that the common law, civil law divide is not quite so hard and fast as it once was. Quite a few institutions have rules which empower the tribunal to appoint their own expert if they wish. And indeed, Section 37 of our Arbitration Act gives any tribunal the power to do just that if they wish. To echo what Robert said, from my perspective, it is essential that my chosen expert be completely independent and definitely not a hired gun. I need to know early on if my case is weak, so that I can try to either find a way around it or settle on the best terms available. There's nothing worse than building a case on foundations built by an expert who has told you what he thinks the client wants to hear, only for the whole thing to collapse into rubble on the first question in cross-examination. Equally important is the need to choose the right expert for the task. That is, someone who knows their stuff, but critically knows what they don't know, or what's outside their area of expertise. Experts who stray outside their comfort zone will be found out and will most likely prejudice their credibility, even on those areas where they are truly expert. As an example, I still shudder when I think of the Griparian case. I can't bring myself to discuss the details of it, but if you want to see an expert train crash, read Bernard Rix's judgment in 1994 1 Lloyd's Law Reports. Of course, it's not just in the witness box that experts earn their keep. I might know a bit of law, but I don't know much about navigation or about engine rooms or about the properties of various cargoes. So I need my expert to tell me what documents and evidence I should be looking for, or to tell me what questions I should be asking my witnesses, and indeed, when perhaps my witness is not telling me the whole truth. In technical cases, it normally pays to get your expert on board early, and in a specialist field, especially so, to get them on board before the other side does. I suppose my final thought would be this: you may be totally convinced that your expert is right and that they support your client's case, but that doesn't necessarily mean that the judge or the tribunal will agree. If COVID has taught us anything, it is that science cannot always supply a single answer to a question that is indisputably the right one. And I'll cut that short there if that's okay, Francesca, and hand back to you. You're on mute.
Yes, now you should hear me. I will hand over to Andrew for the questions, and then you know, as we said, I'm sorry we can't have a physical cheer, but at least probably we'll have a virtual one, and you know, wish everyone then a Merry Christmas. So I'll hand over to Andrew for the questions now. We have a few in the Q&A. So thank you, Ed, once again.
Yeah, yes, Ed, thank you so much for that. It was dripping with experience and wise words. One thing that I'm going to ask about, because Alan mentioned it and it was sort of left hanging, was about preparation of experts. And you mentioned that in New York, you prepare the expert. There are other questions lining up, but I would love to hear, what does that involve?
Well, we go over the expert's direct examination and we prepare him for anticipated cross-examination. And we ask him, as you do with your expert, for helping us with regard what to anticipate the other side's expert's going to do. That's the preparation, both in court and in arbitration. If we use an expert on a bench trial, we're going to do the same kind of preparation for the witness.
Are you permitted to practice questions with your own expert? So I'll say very quickly here, we don't and we can't, or I don't and I can't. Are you allowed to practice, rehearse? Oh, well, I don't think that's the right kind of answer.
Yes,
could you try again?
Yes, I know that's been a big issue with you, but yes, we are.
Okay.
Yes, we are. That's the direct examination where we have the script written out for the expert.
Okay, that's really interesting. Thank you for that, Alan. I promised I would get to some of the questions in the chat. So there's one for Eugene from Peter Daniel, who says, in my experience, it's now becoming increasingly common to have an experts meeting and agree a joint statement right at the start of the process and before reports are exchanged. The purpose is to agree an approach and methodology and document this. What is Ms. Richards' experience of this and her views on this?
Well, it's nice to hear from Peter, but I haven't yet had any experience whatsoever of being able to sit down with another expert and agree the methodology. It can, I think, happen where you've got two large firms of big accountants, and they might start out off together trying to work out what the methodology should be, but it hasn't happened to me. I've always come across, this is partly why some of my reports are so long, because I see the other experts' report and the methodology is so wrong. You know, it takes me, especially if I'm doing a litigation rather than tribunal, where the judge is not a shipping man, it takes you 20-page document to explain why the methodology being adopted is completely wrong. So I have absolutely no experience of what Mr. Daniel is talking about.
Well, thanks for that. Where I've seen it's not necessarily been to agree methodology. Where I've often seen this kind of really early intervention of experts on both sides is in very heavy construction cases, offshore construction cases, or very complicated offshore pipelay vessels, rigs, that kind of thing, where they can get their heads together early on and say, these are the ballpark things that we might want to look into, and this is what we disagree on, because there's just so much to go over. But you're right, methodology, if it comes to a question of delay, there's always an issue of, you know, which methodology is right. But they might want to agree whether they take a Windows approach or another kind of approach to working out delay over a schedule. And sometimes I've seen experts agree that early on, and then one of them tries to wriggle out of it when they realize it's the wrong thing to have agreed for his client.
I would always, can I just come back on that though? You know, the experts meeting early is one thing, but I believe, because all I do is crunch numbers, so all I do is quantum. And I believe quite often, if you go for quantum before you go for liability, you can show quite early on that there is absolutely no case to answer. And therefore you can save an awful lot of time by not even trying to go for liability. Or in quite a lot of cases, liability is obvious. So you still need to have a feel of what the number is going to look like. I mean, I have, over the last 3 or 4 years, I have had so many cases where I can only describe it as opportunistic litigation, where I don't believe the party making the claim has made any losses at all. And it's you need to have that up front before you waste a lot of time working out the liability.
Well, that comes back to something that Ed was saying about, you want to know early on from a properly independent expert whether your case is a runner, whether it's going to fall apart. And on that, I would add that, like Robert said, early intervention of an expert is really important and can save a lot of money in the long run. But clients are sometimes reluctant to engage experts early on. There's a question here that I think I might put Ed's head close to the block for this one, but I'll just read it out. The question is, what about the expertise of the commercial arbitrators in testing the experts put forward? Ed, do you pick your arbitrators based on whether they can deal with particular technical issues? Sometimes, all the time, never?
That is a note I put at the end of my thoughts in preparation for this evening, and I describe it as a bit of a Pandora's box. I think that certainly in the old days, we were much more used to arbitrators who were appointed because of their knowledge of the business and of the issues in the dispute. Increasingly over recent decades, we find lawyers, ex-judges, becoming the arbitrators. I am happy, and I certainly do appoint technical experts to a tribunal in cases where I think that perhaps we are over-lawyered on the appointment side. I would, however, encourage an arbitrator in that position to make clear what his views are in his questions. I wouldn't want him not to ask a question and then go and bend the minds of the others when they go off to consider their award. So it's a bit of a balance there. So yes, I think there is certainly great value to be had. I wouldn't want there to be any preconceptions or issues that weren't ventilated openly.
Yes, well, thanks for that. Robert, do you, does the tribunal before you have an impact on how you feel in cross-examination, how you deal with cross-examination, if you notice that somebody on the panel has got particular expertise in a particular field, or does it not really make a difference?
It's sometimes helpful if one of the arbitrators has got experience in more complicated cases, but overall it doesn't make a difference. No, sometimes you feel that maybe what you're saying the person gets more easily, but it doesn't really affect it, I would say. Yeah.
Great. One question from me: does anybody on the panel have a burning question that they want to ask one of the other panelists, like my question about what does prepping a witness involve in New York? It's still fascinating answer. Any burning questions before we wrap up the session?
I have. Can I
Please.
just say something about prepping? The first time I was prepped, I was incensed. And I went, I don't need prepping. I've done this loads of time before. Why should I be prepped? And they came to London and spent a whole day prepping me. And after the first 30 minutes, I realized that I would absolutely need to be prepping. And one of the things in being deposed was the instruction. I'm a past master of the yes but or the no but answer. In prepping and in deposition, I was advised that the answer in being deposed was it depends, because then you've got to draw the other guy out to ask you the next question. So that was worth the prepping on its own. So you don't say yes but or no but, you have to let them ask the next question. So you go, it depends.
Is that
Andrew? Case.
Is that something that you feel? So the yes but no but is something that I often hear said in not in preparation, but in chatting with witnesses about the range of possible answers that they can give. Right, you say answer the question. This is the range of possible answers that you can give. Not specific to facts, but it's I've no idea to absolutely yes or no, and there's something in between. Yes but no but is sort of in the middle of that. Is even in London arbitration, would you still take that it depends?
Oh no! In London, I would go for the yes but or the no but.
Yes.
And the reason you have to do that is that the barrister wants a yes or no answer. And if you give a yes or no answer, it could be hugely misleading. And you have to therefore extend it to explain why you've said no.
Well, I'm glad you said that, Jean, because an it depends answer, and I didn't think that you would say that you would. An it depends answer could almost be quite evasive after a while.
Oh yes, it's only necessary in the deposition and the prepping side of thing for America, because the deposition is going on record to give a whole load of questions that they can then put forward later in court, so that you're going to make them ask the question, because your but won't necessarily go down as evidence. So you've got to get them to ask the next question in order to get the answer expanded.
This is with regard to your it depends. In prepping witnesses for depositions, the word because is very important. Yes, because blah blah blah. No, because blah, blah, blah. So they give an explanation as to why the underlying basis of their answer. So because is a very important word in prepping witnesses.
Oh, yes. I agree, totally.
Thank you.
That's been a very fascinating part of the Q&A. I think we're at our time limit now. And I would, before I do hand back to Francesca for the last thing, she's too modest to do this herself, but we all should doff our cap to Francesca for all the work that she does for the YMP all through the year, managing the committee and various events. And thank you on behalf of all of us, Francesca.
Thank you very much.
Gerard and Aleka.
Well done.
Thank you very, very much. Once again, to all the speakers, to MFB for hosting this evening event, and of course, to all the participants who, I must say, are joining, as I said, from 32 countries, so despite the different time zones. So thank you very much for that. I found all the talks and the presentation extremely interesting, informative, and certainly fascinating to hear the different approach to adduce expert evidence across the UK, the US, and the civil law countries. I hope, of course, that the event has been useful for all of you. And now all that remains for me on behalf of the YMP is to wish you a Merry Christmas. And if you have a glass to hand, I will invite you to raise it to a happy, prosperous, and hopefully less pandemic affected 2022. And I must say that we very much look forward to seeing you all, hopefully in person in London in 2022. And before we of course, we all go, Andrew, thank you very much for putting this together. I know how many efforts you made, so thank you on behalf of myself, but also on behalf of the whole committee.
Hear, hear.
Cheers.
Cheers. Thank you.
Bye, everybody. Merry Christmas.
Thank you.
Healthy,
Okay.
healthy.
Yeah.
Indeed.
Healthy, everybody.
Thank you, Andy. Yes.
The game.
And a happy new year.
Yeah, exactly.
Right.
Thank you
Thanks,
to you
everyone.
all.
Best wishes to all of you.
Okay.
As chairman of the Baltic Expert Witness Association, I'm delighted to have participated and attended this event, and it was extremely informative, not only for those of us who understand something about the way it works here in England, but also how it is done both in New York and Italy and other civil code countries. Thank you, Andrew, as well, for your comments. I just wanted to add that. Thank you to all, and a happy.
Thank you very much.
That's very kind. Thank you.
Yeah, thank you.
Okay. Cheers, everyone.
Thank you, Ed.
Bye.
Bye.
Cheers, everybody.
Right, thank you.
So thanks again and goodbye, and see you soon, Francesca.
Thank you, Luca. Thanks a lot. See you
Thanks so
soon.
much, Luca. It was so interesting.
Best wishes to all of you. Bye.
Bye.
Stay well to everybody.
Alan, thank you
Thank you,
very
Alan.
much. And we're short. I mean, we're sorry. I mean, we're to cut your time short. We hope to have an event soon.
Thank you very much, Francesca. I really appreciate you and the kind words.